So without further ado, I will hand over to Michael, who will introduce you to the rest of our panel for the day. Thank you.
Hi, yes, thanks, thanks Emma. I'm going to try and share the screen now. So, I was the claimant solicitor in the matter, and I'm pleased to say we've got the two counsel, Rhodri Williams QC and Nia Gowman. So this is all about the case of Driver against Rhondda Cynon Taf County Borough Council. It's a full name. It's all based around Pontypridd. That's the metropolis of Pontypridd, and Pontypridd is famous for Sir Tom, the grog shop, and now this case of Driver against Rhondda Cynon Taf Borough Council. There's a couple of our campaigners there. So this is all about judicial review of a decision made by Rhondda Cynon Taf back in July 2019, it was all about wide-ranging reorganisation of primary and secondary sixth form education in the Greater Pontypridd area. There were four proposals. The proposal of closure of the sixth form at Cardinal Newman, closure of Pontypridd High School, including its sixth form, and Kilfynydd Primary School, turning it into a 3 to 16-year-old, what we call a through school. Similar with Hawthorne High School, again closing the sixth form and reconfiguring it, and the primary school into a through school, and then the closure of a primary Welsh medium primary school up in the Kilfynydd area, and moving that down to a site where there was an existing school and creating a larger Welsh medium school south of Pontypridd. So what we have some sixth form closures. We have the converting of some schools to 3 to 16-year-old through schools, and we have the moving of a Welsh medium primary education school south down the valley from Pontypridd, away from Pontypridd. And so that's the kind of general structure of what we have. So what we're going to do today, we're going to break that down into three areas which emerge from the case. The sixth form argument, which Nia will take us through. The Welsh language, and this is an important part of the case, the equality before the law of Wales of the two languages, and that issue, Rhodri will take us through that. And I will then talk about the third issue which came out of the case, the Welsh medium education, and what I will call the ripple effect, and you'll see what that means when I talk about it in my bit at the end. Okay, so that is the general format today. So I think, so if I can stop sharing now, it'll be Nia, I think, is going to kick us off.
Right, let's share. Right, so you should all now be able to see my PowerPoint with any luck. As Mike has already indicated, my name's Nia Gowman, and I was junior counsel to Rhodri in the thematic case of Driver that we're here discussing today. Mike's already taken you through the background of the case, and I've set out the gist of the background on a couple of slides within my PowerPoint presentation, which Emma's already indicated you'll receive after today's webinar. You've heard from Mike that 4 proposals for school reorganisation were pursued by the local authority. Of those 4, proposals 1, 2 and 3 related to the removal or ending of sixth form provision at Cardinal Newman, Pontypridd and Hawthorne High Schools respectively. So today I will focus on ground 1 of the claimant's judicial review application, namely that the decision to reorganise sixth form education as part of proposals 2 and 3, so those were the ones relating to Pontypridd and Hawthorne, was taken in breach of section 50 of the 2013 Act. And what we'll do is we'll look at what the law says about reorganisation of sixth form education, what the local authority did or didn't do, as was the case, and why the local authority's approach was then held by the court to be wrong. So starting with the legal framework, this is the Act that we're concerned with, and I've set out on the next couple of slides the key provisions that build up then to the key section 50. So school reorganisation in Wales is governed by the School Standards and Organisation Wales Act 2013 and its Welsh language counterpart, the Deddf Safonau a Threfniadaeth Ysgolion Cymru 2013. For our purposes, we start with section 40, which provides that discontinuance or regulated alterations of maintained schools can only be made in accordance with the provisions of the Act. The Act then goes on at sections 41 to 43 to make provision for the local authority to make proposals to establish, alter and discontinue mainstream schools. Section 48 then takes us to the requirement for publication and consultation. Essentially, a local authority or a proposer has to publish its proposals following a consultation process conducted in accordance with the organisational code. Once published, we then get to the key of this case, namely section 50. Section 50 of the Act provides that certain proposals for school reorganisation can only be approved by the Welsh ministers, and where approval is required, section 50 subsection 4 states that the Welsh ministers must be sent copies of the consultation report, that the proposals themselves, objections and any objection responses. Section 50 subsection 5 then provides that the Welsh ministers can either approve the proposals, reject the proposals or approve them with modification. Anything that doesn't then get referred to the Welsh ministers can be determined at local level by the local authority. So this essentially, as I've said, was the crux of the case. Did the local authority's proposals require the approval and therefore the scrutiny of the Welsh ministers, or could they be determined locally by the local authority themselves? So section 50 subsection 1a, as we can see on the slide, provides that proposals require the approval of Welsh ministers if proposals affect sixth form education. Subsection 2 then indicates that proposals affect sixth form education if they are proposals to establish or discontinue a school providing education which is suitable only to the requirements of persons above compulsory school age, and that's the key provision that was the subject of lengthy submissions, or B, they are proposals to make a regulated alteration to a school, the effects of which would be that the provision of education suitable to the requirements of persons above compulsory school age at the school increases or decreases. So as I've said, section 50 subsection 2a is mainly what we're concerned about, but let's for a moment look at what a regulated alteration is, because this was the subject of submissions in support of our construction argument for subsection A. A regulated alteration is set out within Schedule 2 of the Act. Of particular relevance for our purposes are paragraphs 5 and 6. Paragraph 5 is set out within the slide in front of you, the alteration by a year or more of the highest age of pupils for whom education is normally provided at a school, with a school both before and after the alteration provides education suitable to the requirements of pupils of compulsory school age, so under 16, and does not provide full-time education suitable to the requirements of pupils over compulsory school age, so plus 16, i.e. sixth formers. Paragraph 6 then relates to the ending of provision of full-time education suitable to the requirements of pupils over compulsory school age at a school which is to continue to provide full-time education suitable to the requirements of pupils of compulsory school age, i.e. closing a sixth form at a school which will then continue to provide compulsory school education. So those are important provisions that help provide context to, first of all, the decision-making of the local authority in respect of Proposal 1, but also our submissions in respect of construction for subsection 52A. Before we delve into the arguments and how the local authority applied these provisions, I just want to quickly mention section 71 of the Act. Section 71 of the Act confers on the Welsh ministers the power to make proposals for the establishment by a local authority of one or more new community or community special schools, an alteration described in paragraph 6 of Schedule 2. So that's the ending of a sixth form at a school that will then continue to provide compulsory school education. And finally, the discontinuance of one or more maintained schools which provide secondary education suitable to the requirements of sixth forms and no other secondary education. So we'll come back to that very briefly later. So what did the local authority do? So in respect of the Cardinal Newman proposal, the local authority referred that to the Welsh ministers. So the Cardinal Newman proposal, as you'll remember, related to the alteration of the age range from 11 to 19 to 11 to 16. And the local authority in that case acknowledged that this was a regulated alteration for the purposes of 52B, because it involved closing a sixth form at a school which would then continue to provide compulsory school age education for the remainder of the pupils. The local authority didn't, however, refer any other proposals to the Welsh ministers. And most notably for our purposes, proposals 2 and 3 were not referred. So as a reminder, proposal 2 was the closure of Pontypridd High School and Cilfynydd Primary School and the creation of a new 3 to 16 year school on the site of the Pontypridd High School. And proposal 3, very similar, the closure of Hawthorne High School and Hawthorne Primary and the creation of a new 3 to 16 school on the current site of Hawthorne High School. Now the practical effect of that is that because Pontypridd and Hawthorne both have sixth forms, the effect of the proposals would be to close 2 high schools with sixth forms and replace them with schools without sixth forms on the exact same site. So the claimant's case was that proposals 2 and 3 required the approval of the Welsh ministers because section 50 subsection 2A covers proposals to discontinue a school which providing education suitable only to the requirements of persons above compulsory school age, i.e. a school which provides sixth form education, the emphasis being on the education and not the school being suitable only for those over 16. And as Pontypridd and Hawthorne both provide sixth form education, the closure of the schools required the approval by Welsh ministers. The local authority's case was that they didn't require the approval of the Welsh ministers because section 52 subsection A covers proposal to discontinue a school providing education suitable only to the requirements of persons above compulsory school age, i.e. a school which only provides sixth form education. And their case was that the emphasis should be on the word school and not the education being suitable for those over 16, because the only qualifies the school and not the education. And so because of that, they say, well, this wouldn't apply to Pontypridd or Hawthorne High Schools, because as well as sixth form education, they also provide compulsory age education. So the claimant's arguments on the day of trial hinged on the following key points. Firstly, the claimant argued that the word only clearly qualifies the education which is provided and not the school, i.e. education which is suitable for sixth formers as opposed to a school which is suitable for those over 16. The claimant argued that that was clear having regard to the syntax of the English text and submitted on that basis that its construction had to be right on the basis of where the word only appeared. Secondly, the claimant referred the court to the Welsh version of the text, Deddf Safonau Trefniadaeth Ysgolion Cymru 2013, and argued that the location of the word only, namely yn unig, within the Welsh version was consistent with the claimant's contended for construction, thus resulting in parity across both versions. Rhodri will go into more detail in respect of the Welsh language construction point within his talk. But effectively what the claimant said is, on the defendant's case, there'd be a disparity in meaning between the two texts, and that simply can't be right. Thirdly, the claimant relied on the wording of paragraph 5 of Schedule A. So this is the regulated alteration provision. As a reminder, paragraph 5 relates to age range alterations to a school which provides education suitable to the requirements of pupils of compulsory school age and does not provide full-time full-time education suitable to the requirements of pupils of over compulsory school age. The point that was made is that there's no such corollary exclusion in section 52A, and because that doesn't exist, that then supports the notion that the word only must be used to qualify education and not school, because otherwise we would have had a similar exclusion. Fourthly, the claimant relied on the practical consequences of the local authority's interpretation and argued that the protection afforded to sixth form provision would effectively be lost if the local authority's interpretation was correct, because all the council would need to do in any situation where it wanted to close a sixth form without referring to the Welsh ministers as a regulated alteration would be to close the whole school and immediately open a new one on the same site, just with a different age range that did not include 16 to 19-year-olds. And that's what the local authority was essentially trying to do. But it circumvented a whole section of the Act, ultimately, which ultimately has a purpose. Fifthly, the claimant highlighted that the claimant's construction was consistent with the way that education in Wales is organised and funded, because funding of post-16 education, whether at a further education college or at a sixth form in a mainstream school, is direct from the Welsh Government, whereas funding for those before 16, i.e. compulsory school age, is paid through a settlement revenue support grant. So it's therefore logical that the Welsh Government would want to retain some degree of control over post-16 proposals. Finally, the claimant relied upon the principles of Pepper and Hart to highlight passages of the preparatory material in support of its argument. So firstly, the white paper, secondly, the record of minutes of a Welsh Assembly plenary session when the bill was first introduced. And these provisions effectively highlight the importance of the Welsh Minister's strong element of control over post-16 proposals and the interlinking relationship between sixth forms and other forms of post-16 education. The local authorities' argument then hinged on the following points. They said wherever the word only is placed, it must be intended to qualify the school and not the education. And they stated that there's no category of education suitable to the requirements of persons above compulsory school age, which is then suitable for other age groups. They then went on to say that just because the position of the word only doesn't matter in the English text, it doesn't matter in the Welsh text. And Rhondda will go on to explain how that went down with the judge. Thirdly, distinguishing the claimant's argument in respect to Schedule 2, the local authority that said that the schedule relates to schools which don't provide full-time sixth form education, but may provide some. What that is, we don't quite know. Fourthly, when construing the contrasting powers that the Welsh ministers themselves have in section 71 and what must be referred to them by the local authority, they said that the claimant's interpretation would cause an anomaly because effectively section 71 would confer upon the Welsh ministers less power than what should be referred to them by virtue of section 15. In respect of the preparatory materials, the local authority argued that there was no ambiguity in the texts which would warrant recourse to the preparatory material, but even so, the explanatory memorandum, white paper and plenary statement in fact supports the local authority's interpretation. The final point to note in respect of the local authority's case is that they somewhat tentatively relied upon a letter from the Welsh Government dated the 14th of August 2015. That letter appeared to concur with the local authority's interpretation and appeared to suggest that referral to the Welsh ministers in circumstances such as these would not be required. It was conceded by the local authority rather sensibly that of course statutory construction is a matter of law for a judge to determine, that the letter related to different proposals altogether and was not in reference specifically to section 52A. But it was helpful to mention that given the context of the ultimate decision, which seemingly went against that contained within the Welsh Government's letter. So in terms of the decision of the court, I've set out in some detail the relevant passages, but given that time is relatively short, what I'll do is just highlight the key points that came out of the judgment. So firstly, the judge held that section 50 subsection 2 does not set out the only ways in which proposals could affect sixth form education. Now this wasn't a point that was particularly pressed, but it was an interesting point raised by the judge in his judgment. What he said is that section 52 doesn't, or there's nothing within section 50 subsection 2 which implies that this is an exhaustive list of reasons why proposals would affect sixth form education. If it was intended that this was an exhaustive list, the judge said that the word only would have appeared within that provision. Secondly, the judge said that even if he's wrong about that, in his judgment, the word only in the English text quite clearly qualifies the education and not the school, so in favour of the claimant's argument. And he rejected the local authority's argument that the meaning of the sentence is the same regardless of where the word only appears. Thirdly, he highlighted that the Welsh and English language texts have equal status and accordingly both have to be construed. He said that the words yn unig, which is the translation of the word only, are positioned at the end of the section together with the words that precede it, and because of that it is a more consistent it's more consistent with the claimant's construction, i.e. the words in the Welsh version also qualify the education and not the school. He paid short thrift to the local authority submissions that the Welsh text must have the same meaning as the English, or that the words yn unig don't matter in terms of the position because the word only also doesn't matter. And as I've said, Rhodri will deal with that in more detail in a moment. The judge then stated that when construing both texts, the claimant's contended for meaning is consistent across both the Welsh and English text and is therefore by far the preferable construction. In respect of the section 71 point that was raised by the defendant in support of their argument, the judge in fact found that the claimant's construction is in fact far more consistent with other provisions within the Act, and within his judgment he specifically refers to section 71 and explains why in his view the two sections read together do not in fact cause an anomaly and in fact make logical sense having regard to, as I've indicated previously, the funding requirements and the power in respect of section sixth form education. He did not accept that there was an ambiguity in the text, but he went on in a belt and braces approach to indicate that even if there were an ambiguity, in his view, the white paper and the explanatory memorandum are consistent with the claimant's construction for the reasons that I've set out within the slides. So what are the key points that we take away from all of this? First of all proposals relating to sixth form education must now be referred to Welsh ministers. Secondly, this includes, but is not limited to, proposals to close any school which includes a sixth form. So even if the list is exhausted, a proposal to close a school which includes a sixth form, not just a sixth form only school, must now be referred to the Welsh ministers. Thirdly, the Welsh language text of legislation is of equal standing to the English text. And finally, the statutory meaning of the Welsh is not to be derived by construing the meaning of the English text. Rather, the meaning must be consistent across both texts. So the two latter points, as I've indicated, are particularly significant and their effects far-reaching, and Rhodri will now go on to deal with that in more detail.
Thank you, Nia. Let me see now if I can get my up on the screen. Right. Right, can you all see the first slide. I'm very grateful for Nia laying out the background and detail of the section in question. I'm not going to look at that. What I want to do is to concentrate on the last two key points that Nia mentioned, and that the wider significance that this judgment will have for statutory interpretation going forward. The significance of this case, in my view, although the points about Section 50 are clearly very important, as is the point, the ground which Michael will deal with in a moment, but very important. That significance is far wider than that, and indeed far wider than just school reorganisation cases. That's the decision, of course, was given at the end of last month, following a hearing in mid-June. But this was the first time the court had been asked to look at in any detail the provisions of these three pieces of legislation. The provisions have existed, in fact, since the Government of Wales Act 2006, and that was the legislation that was actually in force at the time the decision of the Council was taken, together with the Welsh Language Wales measure of 2011. It's now governed by the 2019 Act, the Legislation Wales Act, and that will be what we'll be looking at going forward. But the provisions are exactly the same. There had, in fact, been a similar provision going back to the original Government of Wales Act of 1998, but as far as I know, that was never called into question. As I say, this is the first time that the court has been asked to look at the practical effect of these provisions of the legislation. It's a landmark ruling for the importance of Welsh legislation in Wales. And it was highly significant the way the court was prepared to interpret and apply bilingual legislation. Early on in the case, the claimant could see the sense in a Welsh-speaking judge being assigned to this case. Obviously, he or she would need to look at the legislation him or herself and couldn't rely on someone else's translation of it. In the event that didn't happen, I should add that the case wasn't presented in Welsh. Indeed, all submissions, apart from some submissions by the Welsh Language Commissioner who intervened, were in English. That wasn't the issue at all. It was whether the court could properly look at both versions of the legislation and understand the submissions made about it and make a ruling. And to be fair to the judge, English-speaking though he was, he did precisely that, having heard detailed submissions on what the meanings of each word in the Welsh version of the text said. Anyway, never again will it be sufficient to argue the English version of the statute dictates the meaning of the law. I mean, that might be so obvious as to hardly need stating, but it's probably true to say that in the vast majority of cases, that is precisely what happens. When asked to interpret a piece of legislation, lawyers, both in the private sector and in local authorities, I'm sure, have a tendency to look at the English version and simply assume that the Welsh version says the same thing. Anyway, the provision in question in the 2006 Act is this, and I've highlighted in yellow the relevant part, namely that the English and Welsh texts of any assembly measure or act of the assembly, which is in both English and Welsh when it is enacted, and importantly, although this wasn't the provision in this case, any subordinate legislation which is in both English and Welsh when it is made, are to be treated for all purposes of being of equal standing. You'll see this subsection 1A then deals with a new act that came into force this year. And that is an important principle to bear in mind, both therefore for primary legislation, subordinate legislation, and it's worth adding, insofar as there is statutory guidance provided for in both versions of the Act, that guidance too. And of course, although in relation to school reorganisation, this probably only became relevant from 2013 because previously we were acting under Westminster statutes. All legislation that is produced by the Senedd, of course, is bilingual, namely produced in both English and Welsh when made. This stems from the Welsh Language Wales measure of 2011, which makes it quite clear that the Welsh language has official status in Wales. No one would doubt that. But subsection 2 is important. Without prejudice, the general principle of subsection 1, the official status of the Welsh language is given effect by the enactments about. And then B and C, the treatment of the Welsh language no less favourably than the English language, and we'll see that wasn't what the council was doing in this case. And C, the validity of the use of the Welsh language. and then you will see subsection 3, which provides that those enactments include but not limited to enactments which give equal status to the English and Welsh and English language texts of both measures, acts of the Assembly and subordinate legislation. And for good measure, I set out section 5 of the Legislation Wales Act 2019. You'll see material, it says exactly the same thing. And note that subsection 2 provides that the Welsh language text and the English language text have equal status for all purposes. What that means in practice, it is simply wrong to read the English and assume that the Welsh is a translation, or indeed the other way around, of course. Now, how did the judge deal with that in his judgment? I want to look at 3 paragraphs in particular. Paragraph 65, which dealt with the position of the word only and an enig, as Nia has just said. This was the council submission. The judge said the council also submitted that because the position of the word only does not matter in the English text, then the position of the words an enig in the Welsh text does not matter either. This is a bold submission to make. In my judgment, it is misplaced where the Welsh text has equal standing with the English text, and I consider it to be wrong. The meaning of the Welsh text is not derived by construing the meaning of the English text and then applying that meaning across to the Welsh text, which is what the submission seeks to do. That is not considering the 2 language texts as having equal effect. Now that was precisely, of course, what the claimant had submitted, but this, as far as I know, is certainly the first time that has been confirmed by judgment of the court. There have, of course, been cases where the Welsh version of the legislation has been referred to, but as far as I know, that's tended to be cases that have been heard in Welsh, where it would, of course, be natural to refer to the Welsh version. And rarely, first of all, have the parties differed in respect of their interpretation of the legislation, but one party, where one party was saying that the meaning was confirmed by the other language version, which is precisely what occurred here. Now, the other 2 important paragraphs are 79 and 80 that Nia's already referred to. Here's part of the first. The judge held that given the Welsh text of the Acts has equal status with the English, the text of both have to be construed. The meaning must be consistent across the text in both languages. The council submissions wholly ignore the Welsh text, then conclude after construing the English text that the Welsh text must have the same meaning or does not matter. I do not consider that to be the correct approach to legislation passed in Wales, both in Welsh and in English, the text of each language having equal status to the other. That was a surprising submission that the council made, I have to say, in the light of the legislation, and to a certain extent somewhat disappointing, even from a local authority in South East Wales. But it really does underline the council's approach to this case. When the language point became apparent quite early on, the council, even at that stage, didn't make any attempts to put in evidence from a Welsh speaker as to what the meaning of the language was, and simply continued to assume that if they were right about the English text, it did not matter what the Welsh text said. And here's from paragraph 80, the council's contended for meaning, the judge said, also requires one to ignore the Welsh text. The claimant's contended for meaning is consistent both in the Welsh language and English language versions, and does not require one to read additional or further words into the introductory passage of section 52 that are not there. It is by far the preferable construction. Nia has explained why the judge accepted what the claimant said about the consistency across the 2 versions. For the claimant, there was no difference, but there clearly was for the defendant authority, and those submissions failed ultimately because the Welsh version of the text did not support the contended for meaning by the council. Anyway, what are the practical implications of this, and what will be going forward section 5 of the Legislation Wales Act 2019? Well, first of all, one should no longer merely look at the English version of any statute, statutory instrument or statutory guidance. And significantly, one should no longer assume that the Welsh version is merely a translation of the English version. That, of course, is the essence of bilingual legislation, but I think it's probably fair to say that there has been a tendency thus far to do just that for lawyers, and indeed even Welsh-speaking lawyers, up and down the country. If there is the slightest ambiguity, or indeed alleged ambiguity, as there was here, in the meaning of one language version, then reference should, in our view, routinely be had to the other language version to see whether that ambiguity may be resolved. It is perfectly possible now, as a matter of statutory interpretation, that the true meaning is not actually contained in either language version alone, but can only be ascertained by looking at both, and therefore sort of fall somewhere between the two. At first sight, that sounds quite an odd thing to say, but all it is doing is ensuring that both language versions are given the same status, and that one looks at both before determining what the true meaning is. It's not actually such a groundbreaking principle of statutory interpretation, though I have no doubt that the textbooks, indeed the opinion on statutory interpretation was referred to by the defendant authority, that such textbooks will probably need to be rewritten or have another chapter added to them, because it is not something historically that the English and Welsh jurisdiction has had to deal with, principally because, of course, nearly all legislation has only been in English. It is, of course, a common situation in other bilingual jurisdictions, Belgium, Switzerland, Canada, and of course, perhaps most important for us, until earlier on this year, the EU, where there are now 24 languages, if one includes Irish, and in order to determine the meaning of legislation produced by the European Parliament, one is routinely asked to look at different language versions, and indeed the Court of Justice will expect counsel appearing before it to do just that if there is a dispute over the meaning of the terms of the legislation. Often, of course, there will be no apparent difference between the two language versions of the legal text. In an ideal world, of course, that is precisely what is intended to be the case. But practice dictates that that doesn't always happen, and of course, parties will contend for different interpretations of legislation, and so one cannot assume that that will be the case. But it would clearly not be wise to make the assumption and thus fail to give full meaning to the words "have equal status for all purposes" under Section 5 of the 2019 Act. This is not to say, of course, that lawyers dealing with each and every case have to be Welsh speakers, but clearly they need to be open to the possibility that there should be recourse to the Welsh text. One would have thought that every local authority can have access to Welsh speakers, whether or not in its legal department, in order to double check this. But it is clearly going to be very important going forward that one is not wedded and rooted to the English language versions of the legislation. And so, I'm sure that face is familiar. I do hope I don't get sued for breach of copyright. I'm not sure I can claim such immunity like the Senate is tempted to do. Anyway, to paraphrase the Welsh bard Dylan Thomas from Undermilk Wood, which I think comes from one Reverend Eli Jenkins, who after one of the songs explained with somewhat unintentional irony, "Praise the Lord, we are a bilingual nation, and thus may it long remain so." Right, I shall hand back now to Michael and wait for your questions at the end. Thank you.
Okay, thank you, Rhodri, for that. Right, so I deal with the last section now. So we go back to where I was. Right, so I'm going to talk about, this is where you might feel hungry at the moment, it's near lunchtime. I'm going to talk about the ripple argument. Our ground was that Rhondda Cynon Taf failed to take into account specific factors, namely that the proposals might affect the sustainability or enhancement of Welsh medium provision in the 14 to 19-year-old network and wider area, and promote access to availability of Welsh medium in post-16 education. So, a bit of a mouthful there, but you'll get the flavour in a minute of this. In other words, the ripple effect. Changes in one part of the education sector in a county has a wider ripple effect on other schools or children in the county. You must have regard to the ripple. The genesis of the ripple argument, I've tried this argument before, previously tried it in the argument about consulting all schools affected by a proposal. So paragraph 3.3 of the old school organisation code says about having to consult with pupils of any other affected school. They must consult with the school's council. So a number of schools, councils of affected schools are not consulted by the council. we tried to run this argument initially in this case, but there were a number of school councils of affected schools not consulted by Rhondda Cynon Taf. The large scale of the plans cause ripple effects which see children looking to attend neighbouring schools which they might not have previously considered. So in other words, changes in school A will impact or ripple on school B, C, D, etc. It's not just the immediate schools who are impacted, it's the schools and the children around them. So that's what I call the ripple argument. And we're trying to run it on the basis of, say, that consultation with school councils, that it shouldn't be just the school councils of the impacted schools, immediately impacted schools, it should be the schools further out, further round and about. But that failed on permission. And I'd actually run that argument before, 4 years ago, in the case of Edwards and Flintshire. And we failed on permission then when Mr. Justice Higginbottom produced a permission judgment, basically kicking that right out into touch. Okay, so that argument was lost there and then. And we lost it. It was one of our grounds in this case, and it failed on permission. So the ripple argument, though, gets resurrected. The Welsh Language Commissioner had been looking into this matter as well, and I'll mention that in a minute, but that allowed us to almost reconsider and recalibrate the argument. So you're looking at paragraph 1.4 of the code. But the main bit there is where it talks about proposals. The proposal affects schools where Welsh is a medium. Local authorities should carry out a Welsh language impact assessment. Come to that in a minute. And paragraph 1.9 says that relevant bodies should take into account the following when reorganising schools. They have to take into account how the proposals might affect Welsh medium provision in the local 14 to 19 network and the wider area. So that's 1.9 of the old school organisation code. Looking at the Welsh language impact assessment, we argued that the Welsh language impact assessment did not address the impact of the proposals on the Welsh language. The judgment on this bit, this is Mr. Justice Fraser, his judgment on the Welsh language impact assessment is, I think, quite important. He says he was actually very critical of the Welsh language impact assessment of Rhondda Cynon Taf. He said it contains a large amount of bold assertions. He said that only about 10% of it was about the Welsh language at all, really. He said the document recites a commitment to Welsh government targets, but it was just a simple recitation of that. He said it failed to assess the impact of closing the primary school in Kilfynydd, and crucially the impact on the communities around it, and children from a reasonable distance away in Ynys y Bull would go into the school in Kilfynydd. It also failed to consider how the changes to Welsh medium primary education might impact on the secondary education, Welsh secondary education. So what that teaches us about Welsh language impact assessments is that they have to be a bit more analytical in their approach, I consider. Bold assertions and reciting of government targets, which a lot of local authorities do very, very detailed and very good impact assessments. But I have seen a number of such impact assessments which are full of bold assertions and recitals of bits of government legislation. And that is just not good enough, according to Mr. Justice Fraser. He says you also have to consider the ripple effect. So you have to look beyond the immediate impact, if you like. You have to look a bit further over the horizon. He said the Welsh language impact assessment has extraordinarily limited content in terms of impact upon the Welsh language of the proposal, and he said it was basically inadequate. So, I'm not aware of much in the way of judgments really focusing on the Welsh language impact assessment. Here we have Mr. Justice Fraser honing in on it. But back to the ripple argument a bit more, and what did Mr. Justice Fraser have to say about that? So remember, the ripple argument was that the local authority failed to take into account how the proposals might impact on the regional 14 to 19-year-old network and wider area and promote access to Welsh in post-16. So the claimant, we also relied on the Welsh Language Commissioner, who had concluded, who had looked into this. I'm not going to go into this bit in great detail because that would be to steal their thunder, but they were also looking at the impact of the proposals in terms of their regulatory regulations. And the Welsh Language Commissioner there, these are the issues that they were looking at in the framework of what their powers and regulations were about. Anyway, Judgment Day came, as Rhodri said, last month for Rhondda Cynon Taf. And in the judgment on the Ripple, Mr. Justice Fraser accepted our submission that changes to Welsh medium education, Welsh medium primary education, impact upon Welsh medium secondary education. So that's your Ripple. If you impact on primary, it must have an impact on secondary. And Mr. Justice Fraser said, it's plain and obvious, basically, that is the case. He said that if you have fewer pupils in getting Welsh primary education, then fewer are going to move up the chain into secondary, and they will be, the phrase, I think he was quoting Rhodri here, was that they will be lost forever. Children who leave Welsh medium primary education will be lost to Welsh medium secondary education. And what we were trying to demonstrate was that the changes would mean that some parents would have to effectively vote with their feet, and children who were in Welsh medium primary or were going to go to Welsh medium primary might not be going to Welsh medium primary in the new proposals, and therefore it would ripple into secondary education. Any proposals to change Welsh medium primary education must therefore consider how this affects Welsh medium secondary education. So the decisions in respect to proposals were made without taking into account this whole principle. The council, they failed to address how the reorganisation of primary impacts on secondary. So he constantly keeps coming back to this key point. The council failed entirely to consider how it would impact upon secondary education, because the council said, well, it's nothing to do with secondary. We're only closing or moving around primary schools. But that, the judge just said, that is not the point. You failed to consider the ripple effect, basically. He never used the word ripple, disappointingly, but he basically was saying that's what he was saying. So the council were in breach of paragraph 1.9 of the code. They failed to assess the impact of proposal on the Welsh language in any meaningful way. And then he said, nor do I consider the failure can be overlooked or categorised, as the council seemed to be saying, as a mere technicality. It is clear how important the Welsh language is to life in Wales. So this is a, I don't know, this is a London barrister become High Court judge, really tuning in to the importance of Welsh language in Wales. The Welsh language is to be treated no less favourably. If people should be able to live their lives in Wales through the medium of Welsh if they choose. Then if the council's proposals fail in any way in this respect, he says that failure is an important one. It's not technical, it's not minor, it's an important failure. And it's, these are the words of the judge, not me, in bold there. So, at last, victory for the ripple argument. The ripple is eaten, and the ripple argument comes into play. So that really is it in a nutshell. That gives us, I think 10 minutes now to deal with any questions. Thank you.
Thank you, everybody. I have had a couple of questions come in through the live chat. I don't know if David is around and would like to ask his own question, or I can do that for him. There we go, David Gardner.
Hello, everyone.
Hi.
First of all, thank you very much to everybody. Really, really interesting talk, and well done on getting a really excellent judgment. My question was really based around the judge. I wonder if there was any consideration, given the issues in the case, to having a Welsh-speaking judge, or indeed a divisional court, with one of the judges being a Welsh-speaking judge, as has happened in the past. Thanks very much.
Well, perhaps if I can answer that, David. As I did say, actually, the claimant did realise that this was going to be important, and we did make an application for further directions, including that it should be listed, as you say, either before a Welsh-speaking judge or with a Welsh-speaking judge sitting. We were thinking in particular of His Honour Judge Milwyn Jarman. He's previously sat, in fact, he sat with Mr Justice Higginbottom, as he then was, in a case which was actually heard in Welsh, with instantaneous interpretation, and I thought the court would go for that, possibly because the application was made a little late. I don't know. There was a huge gap for some reason, a huge delay between the application for permission and permission being granted, which meant that time had become quite important. That application was turned down. All I can say is, even in the absence of being Welsh-speaking, Mr Justice Fraser did an admirable job on interpreting both versions of the legislation, and I have to take my hat off to him.
Thank you. But just before I jump in with a question via the chat, is there anybody else that would like to ask a question themselves? No, that's fine. So I think this is for any member of the panel of speakers. So the question is, do you think the intervention of the Welsh Language Commissioner impacted the outcome of the case? And secondly, do you think the ripple effect argument could also apply to issues such as provision for pupils with additional learning needs? There's two questions, sorry.
Well, I'll deal with the second bit of that. I mean, the ripple argument was very much linked to the code there. So it's all about the impact of, and particularly in the case, it was looking really at the impact of the language. So I think the original ripple argument, which never got anywhere, is probably more wider. But equally, what the judge is saying here is that I think he's not linking it. I think he's not linking it wholly to ALNs or special needs, but I think the general point there is that you need to look at your education estate more in the round, and if your local authority are trying to kind of really compartmentalize a school reorganization, then then this case could come back to bite you, because the general thrust of the judgment is, do not compartmentalize school reorganization. There will be ripples, there will be effects. So if somebody could say that there was a wider impact on special needs in the county from a particular school or a couple of schools being reorganized, then I think the door is now being slightly opened for that kind of argument, whereas before, certainly Mr Justice Higginbottom wasn't very keen on it, and before it was so we had these much more compartmentalized school reorganization. So I think the way is open slightly for that kind of argument now, but it will depend on the particular facts as to why that would be rippling through in terms of special needs. In terms of the Welsh Language Commissioner, well, perhaps one of my colleagues could answer that.
Nia, do you want to go first?
I'll mute you, Nia.
Is this in terms of the Welsh Language Commissioner point and their involvement? I do think certainly from my perspective, there seemed to be a moment early on in the case when Rhodri was doing his submissions, whereby the judge had a sudden "oh gosh" moment when he realised that the force of the submission that was being made in respect to the Welsh language text. So I think from that moment on, he made such a concerted effort, I think, to really grasp with the Welsh language version. In terms of the Welsh Language Commissioner's involvement, my perspective is that he felt almost somewhat reassured when the Welsh Language Commissioner's translation or agreement to our translation of that text for the same meaning as what we were suggesting. So I think in terms of whether that made any difference, I think it on two fronts. It highlighted to the judge the significance of the decision he was being asked to make, but also the reassurance point of the Welsh Language Commissioner being involved from a confirmation of the translation that was being presented to him. So I think to some extent their involvement was very helpful in the case and helped drive the Welsh language point forward.
Thank you. I've got a couple of other questions if everyone's got time. One of the comment more than a question, and I hope the individual, I won't name them, but the individual doesn't mind me sharing this, has said that this is the most interesting case with interesting repercussions for Welsh language, interpretation, etc. But for me as a parent who fought these proposals from the outset with extreme frustration, I've listened to the seminar with tears in my eyes. It's extremely emotional for us to have had our voices finally listened to. So I thought I'd share that because it was a really lovely comment, and I really appreciate that on behalf of the speakers. Another question I've had is, could this judgment be used to review previous decisions or reorganisations made either by RCT or other authorities? Good question.
Well, I think any court faced with someone trying to reopen an argument would say, well, why didn't you do this before? Because of course, if the point was good, if the point is good now in relation to a specific piece of the statutory interpretation, it would have been good then. And I suspect people would get short shrift if they tried to open up an appeal, which would presumably be out of time, on the basis of an argument that they could have made previously. I think the significance of this case is going forward, to be honest with you.
Thank you. Any other questions or points for the speakers at all? No, fantastic. As I said, I will share all the slides from the speakers plus their contact details if you want to get in touch with them about anything more complex. We'll also share the recording link with you within 24 hours so you can share that more widely. I hope you've really valued today. I think it's a fascinating case, and it's exactly the kind of thing that we like to cover on Legal News Wales. Thank you for joining us. Thank you very, very much to our speakers, to Michael, to Rhodri and to Nia. Have a lovely afternoon, and I hope to see you again very, very soon. Take care.
Sure.